Welcome all of you. As they say in the airlines, when I fly American Airlines, they say, we know you have many choices. We're so glad you chose them. I'm really glad that you came. And I also want to welcome those who are online. We are going to have the conversation until about 6:20 p.m. and then we'll open it up for questions and comments from you, the audience. So, Dean Crowell, you start the conversation. Thank you.
Thank you so much, Professor Andrews. And I just want to say Professor Andrews' leadership here at the law school is unparalleled. Really tremendous work. You know, as a scholar and public intellectual, incredible presence for this law school in the international arena and law and society. And thank you for all you do and your important work that helps all of us have some light. And so I'm grateful for that. And it's really an honor. It's an honor for me to welcome two wonderful jurists. Thank you, Justice Theron, for being with us today. I really appreciate you traveling here. And Judge Rivera, thank you so much. You're Senior Associate Judge of the Court of Appeals. And we have the pleasure of working, we as law school deans have the pleasure of working with Judge Rivera. She is the liaison to the Dean's community in New York. And, you know, it's interesting that we're in Tribeca Global Center tonight. Most recently, the judge helped our law schools throughout the state and beyond with dealing with issues concerning visas for international students that was a crisis averted. And we're grateful for the efforts of the court and your leadership. So I just want to make sure I thank you for that. It's really greatly appreciated. So tonight's dialogue, as Professor Andrews said, is not only hosted by NYLS, but also the Historical Society of the New York Courts. And we're going to explore rule of law and constitutionalism, ideas that lie at the heart of every democracy, but that take on different textures in different constitutional traditions. And as we discuss judicial decision-making and the cases that have shaped both the New York and South African courts, I hope we can also reflect on how courts serve as civic teachers and how judicial reasoning, transparency, and integrity strengthen public trust and nurture the habits of citizenship. At NYLS, we recently convened our Constitution and Citizenship Day Summit. This evening continues that conversation and reminds us that understanding the rule of law is not only a matter for judges and lawyers, but for every citizen who helps sustain democracy through engagement and inquiry. I want to give a quick shout out to Julia Rose Kraut from the Historical Society for being a key partner in that Constitution and Citizenship Day Summit. That work continues, and we will continue to be partners, and I'm grateful for that. So within the frame of the discussion this evening, we have a number of topics, and I want to discuss first shifts in judicial roles and contexts. You both became judges more than a decade ago, and during that time, the world has changed dramatically from the COVID-19 pandemic, shifting economies, and new social challenges, including polarization in public debate. Reflecting on your own experiences, and of course, broader observations, would you comment on one or two significant shifts or patterns you see regarding the role of the courts and your specific roles as jurists? Justice Theron?
Yeah, thank you. Thank you, Dean Crowell. It's an honor and it's a privilege for me to be here this evening and to be part of this distinguished panel with Judge Rivera and with our dear common friend, Penny Andrews, who is in South Africa, also very legendary in our profession and in academia. When I was appointed as a judge, I was the first Black judge and the first Black woman judge to be appointed in my province. When I reported for duty and I went to the restroom, there was restrooms for judges and had a male sign, and there was restroom for secretaries and had a female sign. So I decided I had bigger battles to fight than to have restrooms for women judges. And for as long as I was at that court, which was 10 years, I used the restrooms for secretaries. But I think the lesson for me was that there were bigger battles. I was the first Black woman judge, and I knew that if I didn't succeed, I would make it harder for other women to come after me. And in 1994, there was one Black judge in the country and one white woman judge. Our landscape has changed considerably since then. And it's only 30 years now that women have been accepted as judges in the judiciary. And before that, it was seen as a role only for men. And before that, only a role for white men. And there, a famous remark by one of our former deputy chief justices, he said, for Black people, justice had a white imposing face. And so we've moved from a judiciary that was enforcing apartheid legislation to a non-racial judiciary, a judiciary under the Constitution that is working towards a transformed, united, equal South Africa. The pandemic, when it came, we didn't know what's going to happen, what changes they're going to be. We knew there was a shutdown in March 2020. We didn't know for how long. After the first shutdown, we realized, well, we have to make ways of working, otherwise cases won't get heard. Then we started online hearings, and they were extremely successful. What they also did is they brought the Constitutional Court, which is the highest court in the land, onto YouTube. So everybody who had a cell phone, everybody who had data could listen to cases. That also happened with our parliament, by the way. There was more streaming. So one of the positives that came out of it, people became more aware of the work of the court and what the court was doing. But with that, also there's lots of memes. And I recently penned a judgment which said that a man, if he wanted, could take his wife's surname. Because before that, the law didn't allow that. So I said that law, well, me together with my colleagues, is about 2 months ago. Then there were all these memes about Judge Theron was an enemy of the state and was responsible for the downfall of men and for men as we know it. And they must ask Judge Theron, you know, are women also going to pay lobola? And they had memes of men, pregnant men. So, you know.
People were paying attention.
But
they misinterpreted and certainly misapplied what you were doing.
But definitely what we are doing is since COVID is getting a lot more attention by a lot more ordinary people, not just those who are affected by the judgment and academics.
That's great. Judge Rivera.
Great. Well, thank you for the invitation. Thank you to Professor Andrews, a dear friend and colleague, and for a good number of years, shall we say. We're both young. And this wonderful opportunity to meet Judge Theron and talk about these respective issues, and always with the Dean. I also want to thank the many members of our judiciary, our state judiciary, who are here. Some I have known for quite some time, including from law school days. And it's so nice to see you all, and other people are here today. By the way, what is the rumbling? Is that the subway?
That is the subway.
It's always great to be in New York City. Thanks so much. Okay. Well, this was such an interesting question, and I went back and forth on it, taking notes of what did I want to focus on, the common law tradition of the New York Court of Appeals. Did I want to talk about some of the issues that have already been mentioned about these other transitions in the judiciary, from a judiciary that reflected sort of one demographic, one particular perspective on life? Did I want to say something about this particular moment? And I think we're going to touch on all of those things before our conversation is over. But I think now I just wanted to mention two things in response to this question. One, that when I first came to the court, and it's been about 13 years now, I came to that court with the same reverence that I had as a law student, right? As law students, the New York Court of Appeals, New York courts, setting the tone, the High Court of New York, Cardozo's court, the court that built tort law, right? And these other areas on the cutting edge of so many new and interesting novel legal questions. And we do have those questions, of course, at the High Court, but there has been although this is something that has been a part of the ether in law schools for a very long time, this attempt to turn the court's focus specifically on state constitutional law. We hear it, of course, through social media. We hear the advocates talking about it, but we do begin to see it in the briefing, slowly but surely. This turn to the state courts and the state constitutions being somehow so different from the federal constitution, more expansive. Of course, Justice Brennan had talked about this decades ago. Even when I was a law student, he would come and visit the law school NYU and talk about these issues and say, you know, when the federal court turns its back, it is the state courts and the state judiciary would jump into the breach. That was his famous saying about turning to the state courts. And I think there is something to that. So I'm very interested on what this turn will be, because the reality is that most practitioners at the trial level do not preserve a state constitutional claim. So we have the issue that are bread and butter issues. Have you preserved it? Is there a procedural bar? Can we get to the substantive issue? But when we do, then we have the other challenge of, well, how different is our state constitution if you're almost using words that are verbatim found in the federal constitution? Where do we find some historical basis for saying, even if the words are exactly the same or similar enough, that nevertheless, the argument being the state constitution has a broader reach, is more protective of individual rights. So I think that conversation is going to be very interesting. There have been a couple of cases where we have touched on this. Anyone who reads those cases, I'm not going to tell you anything you won't see in the reading. I have tended to be on the side where our state constitution reaches much broader, provides greater protections. But again, we'll keep moving in that direction in terms of developing our state constitutional law, because I think that is what litigators are looking to do. So that will be an interesting turn of events. I think the other thing is that certainly when I came on the court, there's nothing new about judges being politicized and the courts being politicized. Again, that's historic. But I do think that this is a very different moment. The targeting of judges in particular ways, the voraciousness with which we are criticized, our decisions, if they're not the way a particular individual or group wanted the outcome to be favorable to them, is wrong. Not wrong on the merits, like not going through the merits. What's the weakness in the analysis? But wrong because we're just terrible people. Right? These are terrible people standing in the way of our progress, of our movement in a particular direction. And I think that is very different. Certainly the violent attacks and the threats on judges is very different, and the need to be have heightened awareness of security is very different. But this way of politicizing judges, which I think is much more personal than it has been in the past, much more about the individual being either incompetent or a terrible judge, so that kind of language is ad hominem attacks, as opposed to a different viewpoint of either the Constitution or legal jurisprudence. And it's a viewpoint that, you know, it ebbs and flows. Sometimes it's in favor, sometimes it's out of favor. I think that is different, and I'm not sure if that will change dramatically in the future. But I think judges overall as a group are deeply concerned about it for our own protection, but for democracy.
Yeah, the independence of the judiciary, it's the preservation of that.
Yeah.
It has to endure. And not compromise.
Yeah, we're not politicians in black robes. That's kind of the bottom line. And I think it's very difficult for the community generally to fully appreciate that. Not so much because most people may not be fully aware of the work that goes into making a decision, right? Ruling on things, being a judge in the courtroom or being an appellate judge, whether it's the intermediate court, the high court. Most people still are not well informed about that. And I blame in part our own profession, that we keep sort of the mystery, right? The mystery of the law and the law degree. But also because it serves a purpose to sort of keep people not as well informed as they should be.
I appreciate your emphasis about sort of the development of state constitutional law. State constitutional law, perhaps more than in recent memory, is taking on new meaning, and hopefully the public is coming to understand more broadly how important it is to their everyday lives, even though they haven't historically appreciated it as such.
Yeah.
So let's move on to the subject of political questions and judicial independence. Unlike in the United States, South Africa's constitution doesn't recognize a political question doctrine. And that is that courts should not rule on certain issues that, because of separation of powers, are within the purview of the executive or legislative branches, thus making certain questions, as we would say, non-justiciable. As a result, the South African Constitutional Court has sometimes weighed in on politically sensitive matters, including how the president should appoint the Chief Justice or the head of the National Prosecuting Authority, or whether Parliament has performed its constitutional duties. So, Justice Theron, how have South Africans responded to this? Has judicial engagement in such questions affected public confidence in constitutionalism or provoked any backlash?
I think the separation of powers principle in South Africa has actually strengthened the role of the courts, because there's no particular field that is taboo for the courts. The courts can look into any field, any matter, but we do have a strict separation of powers. So the Constitutional Court in particular can test if Parliament has behaved in or conducted or passed legislation that is unconstitutional. But where we draw the line is to make new legislation. So we'll test the legislation and we'll say this legislation is unconstitutional, and we'll say why it's unconstitutional, and then we'll send it back. Because of the separation of powers principle, we'll send it back to Parliament for Parliament to do their job. But the doctrine does not prevent the courts from holding the other two arms of government to account. For example, it can even hold the president to account. It can, and the Constitutional Court is the only court that has the power to declare the conduct of the president unconstitutional, or the conduct of Parliament. So in those cases, we have what is called direct access. So parties can come to the Constitutional Court, which is the highest court in the land, as a court of first instance, because it's a direct access matter that falls within what we call our exclusive jurisdiction. If I can give two examples of where that has happened. The Economic Freedom Front is a political party in South Africa. They brought a case against the Speaker of the National Assembly. They said that the Speaker of Parliament, had refused to hold the President accountable because the Public Protector had found that the President of the country had breached his constitutional duties. And they said, because the Speaker is from the same political party as the President, the Speaker failed in her duty. And that matter came to court. There were split judgments. There were 4 judgments actually, but the majority held that the president had failed in his constitutional duty to obey and to follow the remedial action of the public protector. We had another matter, and that concerns voting, where Mkhonto Wesizwe, another party, fairly new party, and a former president was the head of that party. And the former president had been convicted by the court for contempt of court. And the legislation said that if somebody has been convicted and sentenced to 12 months imprisonment without the option of a fine, they could not stand for election to Parliament as a candidate. And there was a little bit of a twist because the former president had benefited from remission. So in effect, the former president was pardoned by the current president. They both had previously belonged to the same political party, and he only served 3 months imprisonment. And he came and he said, no, well, he's been pardoned and he's eligible to stand. And the Constitutional Court found that he was not eligible to stand and to run again for elections. So in a sense, and I'm not because I'm biased and I'm part of the court, I think the court has stood firm in enforcing ethical, appropriate, constitutional behavior from Parliament and from the president himself or herself, even though we haven't had a female president yet. So we've used the separation of powers doctrine to intervene and to hold accountable.
Judge Rivera, from the U.S. perspective, how do you view the balance between judicial restraint and constitutional accountability when courts face politically charged disputes?
Well, there's more and more of the politically charged
Yes.
disputes, which is an unfortunate trend. When two other branches are not actually doing their work, some people apparently think that we should do it for them. And I think that is a very dangerous path for us. But putting that to the side for the moment, it strikes me that what we're very good at and what the Constitution requires of us is to, when we get those kinds of questions, to say, well, this is your constitutional duty, or this is your statutory duty, this is your mandate. And what you just did is unlawful. These are the things you can't do. We're going to leave it to you to figure out how to exercise your authority, how to address this problem that you've identified as a problem that you wish to address. But we're on, I think, weaker ground when any court says, well, this is the only way it can be resolved. Sometimes they leave us no choice. But the reality is that our role is to say, this is what the Constitution demands, this is what the statute requires, these are the things you can't do, go figure it out, right? Because many of the choices that we know as policy choices involve a little bit of haggling amongst elected officials. What I might think if I was an elected politician as the way to resolve something is not necessarily what I think is appropriate for me to say from the bench. So I think it is very close to what you've described, sort of this understanding of this is where we sit in this constitutional framework, where we think you all sit in this constitutional framework. So we have now told you that what you've done is not permissible. You've got to go figure out how best to resolve it. Maybe there'll be more litigation around whatever you come up with, but nevertheless, we're putting it back. I agree with you that in that way, there is great similarity. I do think, though, that to the extent, again, that the public does not fully understand these concepts, because there's not necessarily an education system that helps our community, especially when they're young, young people, to really understand the way the law functions and what judges do, what lawyers do, what politicians do, these other branches do, that people may feel unsatisfied. They may feel either judges should step in to the breach and do something, or that we've gone too far, right? It's not that easy without legal training on some of these complex issues as to where the line is. And frankly, it's often a complex question as to whether or not it's a judicial, right? It's a political question that the judiciary should not be involved in trying to resolve. Sometimes we disagree about that, which shows how complex this whole area can be.
Great, thank you. Another topic is anti-corruption and the rule of law. And in some respects, you answered part of this question that I have, but I want to get into the meat of it, which is around the world we see growing concern about corruption and how democratic institutions are compromised as a result of it. It's not in any one country. It is pervasive, and and there are glaring examples of it, despite many efforts to thwart it. How do courts help to counter corruption and restore faith in rule of law?
I think firstly it's important for the judiciary to be above reproach. Because
Lead by
if-
example.
yes, if there is seen to be judiciary within the corruption in the judiciary, then the judges lose all credibility in the eyes of the public. And there have been in the past year or two some allegations that have been made against the judiciary. And it's part of the Madlanga, former colleague of mine who retired recently. The president established a commission to investigate corruption within the police force and within the judiciary. But prior to that, we had the Zondo Commission, and that was a very big commission that looked into corruption, and that is where our former state president was implicated in that commission. And it's when he refused to testify at that commission that he was charged with contempt and sentenced to 12 months imprisonment. So there will be those who will say that the government is not doing enough. And there will be those who say the courts are not doing enough. But the hands of the judges and the judicial officers are tied to a large extent. We don't determine which cases come to us. That is decided by what we refer to as the NPA, the National Prosecutorial Authority. They decide which cases, even which cases of corruption. And at the Zondo Commission, lots of evidence was laid. And there's been a lot of unsatisfaction, unhappiness amongst popular people that the evidence is there. Why aren't those people being charged? And it's not a question that the judiciary can answer. But I would like to believe that from our side, we're doing what we can when the cases come before us. But it's also about evidence. It's about investigations. If cases are not investigated properly, there's not enough evidence. And if they have to be withdrawn, it's not the judge's fault. And sometimes in the eyes of ordinary people, it's seen as though the judiciary is part of this corruption. And there's no will on judges to end corruption. So it's a difficult, complex area to understand.
Thank you. Let's go to the subject of judges' public trust and civic education. Judge Rivera, in an age of intense public discourse about democracy and the rule of law, and in the media, on social media platforms and scholarly articles and books, what do you see as the judiciary's place in that conversation?
Yeah. Thank you for that. So I think in addition to deciding every case based on the law in front of us, making sure our proceedings are fair and just, again, getting back to educating by modeling professionalism, modeling the highest ethics that our profession is held to and more. It is about being involved in outreach and education. I don't see that in any way violates any professional rules of conduct. I wish I could say that the schools are doing a bang-up job of educating our future generations on how the law works, what lawyers do, how judges decide cases, what issues we can render decisions on, what you were describing before, what is off limits, but they're not. So we can either boo-hoo about it or try and do something about it. Now, the reality is that judges do a lot about this. Judges individually spend a great deal of time going out to schools, speaking to both adults and younger people about the law and about their work and their own history getting to the bench. So it's not for lack of trying. And then, of course, we have more institutional attempts at doing that. The Second Circuit, of course, if anyone has not visited the Second Circuit, the Thurgood Marshall Courthouse, God rest his soul, Judge Katzman did a fantastic job setting up an entire program and space in that courtroom where students, young people come and students come to learn about the work of the federal courts, to learn about our democracy, to learn about the role of the national government, which is fantastic. And so we also at the state court level have programs where we coordinate both internships, people going out, and these, I think, at the micro level are really, really important. But I do think, and perhaps I'm wrong about this, but I think sort of at the macro level, to me, the real problem is that people do not understand that a judge is not corrupt just because they ruled against you. That is not corruption with a capital C. Just because someone holds differently does not mean that they are not following the rules of the profession, have violated their ethics, have accepted a bribe, anything else you want to describe as what would be corruption. It's not that the judicial branch is corrupt because sometimes it renders a decision that is unpopular or that an individual in a case thinks is not the right decision. That's what happens in a case. There's a winner and there's a loser. Frankly, they're usually both losers because they're not usually getting everything they want. Right. But nevertheless, this is the way it's commonly discussed, the winner and the loser in the case, right? And so I think that sensibility, yes, we have to work sort of at educating our population, making them understand what we do, but there's something really much deeper about that misunderstanding, that it can be a fair and just system and your argument will not prevail. That's a hard thing for someone to process, but that is really what the integrity of the judiciary depends on. People accepting a decision that goes against their view. Now, there are other ways in our democratic system to address that, but it's not by calling the judiciary all corrupt. That does not get to that problem.
Let me ask you, when you write opinions, obviously you're writing to address the matter before you, but who do you view as your audience in the broadest terms, and how do you use that as an opportunity to educate the public about constitutional values or the meaning of justice?
Yeah. Well,
civics lesson in the decision.
I know. Well, always the hope that people will read it, right? Not just the couple who must, not just the parties and the judges below. But in any event, the audience always has to be the general public. I strive, I don't always reach the goal, but it is my goal that whatever I write, and I think this is true for my colleagues, that anyone who picks that up, even if they have not been educated in the law, even if they don't know anything about the case, can understand what's gone on in the case and can understand why the court came out a certain way, and if there are separate writings, why there's disagreement. Again, they may not be persuaded by it, but to understand how we reach that determination is the goal, right? So the general population is always the audience. But then, yes, it does depend on the issue. You may be speaking in a very pointed way to the legislature, pointing out that this is an area that cries out for a resolution, right? There's an unintended consequence. It doesn't seem like this is what the legislature intended, but this is the plain text, and it does seem to be supported by some history. We're pointing it out to you. Or maybe the majority has decided it one way and a dissenter will say, it is now only the legislature who can change this outcome, right? Because it's a statutory fix. If it's a constitutional matter, it then is an amendment to the Constitution. So sometimes we're speaking to legislatures. Sometimes, again, depending on the issue, because at the appellate level, we give great deference to the trial judges. We may be speaking to the trial judges about what we see as perhaps a very challenging issue that they face in their courts and how they have approached that. And perhaps there's something that they need to think about and address in the way they've taken that up. I'm going to give you an example. A case a few years ago, it was in a family court case, and this is an ongoing problem, so I can only say but so much about this, but I'll just talk about what I wrote at the time. which was that an attorney had decided to stay silent when their client was not in court. It is an open question about what to do. Should one accept a lawyer's silence? Or, as I wrote, there are apparently statutes and professional ethical rules that do not permit that. So how will we resolve that? My hope at the time, I think it was obvious in the writing, was that family court judges and family court litigators would begin to think about that issue. Eventually, it might percolate up to the Court of Appeals. Maybe we'll resolve it, maybe not. But that was an issue that was particular to a strand of the bench, a particular group of litigators and their clients, and to identify it in that way. So sometimes it is the audience is driven by the issue itself.
Are you unique to family court practice?
Correct.
Yep.
Correct.
Similar experience for yourself?
When I started as a judge, we went for training. And part of the training was judgment writing. Who are you writing for? Because you can't write every judgment in the same way or as an academic, great academic exercise. If the matter is really only going to be of interest to the two parties, to the litigants, then you just write for the litigants. It might be, as Judge Rivera said, you write to give indications to the legislature as to pointers in a certain direction of what might be considered appropriate for the future and for future legislation. You might also write for academics because academics play an important role in teaching, and I think they use some of the cases that comes out. And at different levels of the judiciary, you also write in different ways. Almost every case that's out of the Constitutional Court is a case of public importance. It's an important matter for legal policy, for impact, or it's an important constitutional issue. So we're writing for policy, we're writing for government, we're writing for other courts as well. And we have a recent case. Judgment is not out yet, so I can't say much about it, but watch the space. It's how we interpret rape laws. And sometimes we interpret the rape laws to that actually harms the victim. And so the courts have to step in because the law's there, the law's equal in most cases, but it's how we interpret and apply the law that can have an unequal effect.
Can I just add on that point? There are certainly times that I've written in a particular way because I wanted the litigant to know they had been heard. Not the lawyer, the lawyer's been heard, but that their client has been heard, especially if the client is one that they may very well be a victim of a crime or just a marginalized voice overall. That it's important that they know that they were heard. That, again, it may not have worked out the way they wanted. That's not what I mean by heard. That their point was understood, that they were not sort of blowing into the wind and no one kind of grasped it, but thought about it and tried to react to it, recognize their dignity, their humanity in that moment. And I think that is important, especially for a high court to be able to do that, to show that the judges understand this role that we play in deciding these momentous issues in people's lives. At the end of the day, that we're deciding at the High Court, of course, this issues of statewide importance, but there are human beings right in front of you at the time. And something's going to be resolved for them, for better or for worse in that moment.
Thank you. And why don't we go for some questions? And I have more questions here as well, but we had a question over here just a minute or two ago.
What is your perspective on dissents? When are they important and when are they effective?
Try that first. Can you maybe try that first? So, having penned one or two of those, or a few more. So, well, I will speak for myself. I take no pleasure in a dissent because it means the position that I thought was correct, the way to resolve the question, has not been the court's determination, right? We've not decided it the way I thought was the correct way to resolve the question. And so in my view, the law has lost. And so I do not take any pleasure in writing a dissent, much more prefer the majority. But the role of the dissent, there are sort of main roles of a dissent. One is speaking to the future, whether it's to future legislation or a future constitutional amendment or a future shift in social perspective that may then change the direction of the law. So you're speaking to the future in that way, in the hopes that you'll be vindicated. You may not be around for it, in the hopes that you'll be vindicated by it. We've seen enough of that, I think, over time. So there's that. And the other dissent is the one where perhaps you're on the other side of speaking to the legislature, right? The point is, let me identify what the problem is and point out to a different entity in our democratic governmental structure that can resolve this, because surely this cannot stand. Surely there's something wrong with this. So there's that part of the dissent. And I think, not to be too cheeky, I think there are times when you want to point out the nonsensical approach of the majority, because you're concerned about that precedent being repeated, right? So there's precedent in this sense. It's one thing to have a decision that controls. It's another thing to have a particular analysis that a dissenter might think that is nonsensical. That is contrary to everything we understand. It's not even supported by the record. And in the hopes that that analysis will not be replicated in the future. So sometimes the dissent, not to focus on that hominem attacks of any individual, but on the reasoning of it, to try and undermine that reasoning, and for a future court not to adopt that reasoning and to perhaps move on from that prior decision.
What are your thoughts on dissent?
Yes, I agree 100% with what Judge Rivera has said. I think dissents are important. I think dissents add a richness to the jurisprudence. And it's also intellectually mature, where we can dissent and still work together in a collegial manner. And we are a robust court. There are times when there's more dissents than others. But what the public don't understand, that when we dissent, we're not fighting with each other. We're disagreeing with a principle. So they think that we are arch enemies. And so they're very surprised when they come to know how collegial the judges actually are amongst each other. And I think that's such a good way to deal with it. That if you dissent with somebody, you play the ball and not the person. Yeah. And you never make it personal.
Yeah.
Do you think that's changing at all?
What?
Is that changing at all, given the dynamics out in the world?
Well, if you have any colleague who does lodge ad hominem attacks, I think it makes it very difficult to come back from that. But if you mean like sort of these external views that are thrust upon us, no, I don't think it does that. I will say one other thing about this dissent, because you're absolutely right. I'm so glad you pointed that out. That the other thing, before it becomes public, the other role of the dissent is to challenge the majority. And I frankly think the majority ends up being stronger if it really responds to an effective dissent. Because they're going to have to deal with that issue. Otherwise, they look foolish. And they're not going to persuade. They may persuade the 4 votes they got on my court, but it's not going to go further than that, And so in that way, and the majority then makes the dissent better. That back and forth hones the writing and the thought process. So there's that other role in that.
Do you think it strengthens the advocacy over time? To help
at the podium, or you mean amongst the judges?
At the podium. To understand.
Well, I do think that if someone comes in and we get this, of course, because we're on the high court on occasion, and as requesting that we overturn precedent. And there have been dissents below or over time that they better have a good way of thinking about how they can turn that dissent into what should be the proper approach. Not that long ago, Judge Abdul Salam wrote this majority where we overturned precedent, and she very effectively used a dissent written, I believe then she was Judge K, not Chief Judge K, as prescient, as society has finally caught up to Judge K. You know, this kind of finding a way to do that, which some of that came from the advocacy, but it was her ability to use that in that way. And so I do think that dissents can also, although I say this, we have to be cautious about it. I don't know if you agree with me on this. I think you have to be cautious that you're not looking like you're presenting the blueprint for the next bit of litigation. You have to be very cautious about that, because that is, I think, where the public begins to doubt us. Say, well, you're just trying to be the lawyer for the side that you want to win, as opposed to just deciding this issue before us. I think it is appropriate to show the weaknesses in the argument, or to say this argument was not presented, so we don't opine on it, right? You're letting them know, well, you didn't argue that. Maybe you win, maybe you don't, in that way. So I don't know if you have a view on that.
Yeah, no, I agree with that also. Because you see, a dissent can also be dissent reaching the same outcome, but for different reasons. And a dissent reaching a completely different outcome. And I don't think a judge should dissent for the sake of dissenting, or dissent to show how clever or that he or she can think so much differently. I don't think that's good. And I train judges as well in South Africa because of my years of experience. And there have been one or two dissents that I have written which have become very important over the years. And even though the legislation might not have been changed, but the young people will tell me, oh, there's been so many thousands of times that dissent has been mentioned. They know how to search all of that. And sometimes new judges will ask me, do you write a dissent to become famous? No, you don't. You write a dissent when you have a principled view about a particular matter. And I think it's courageous to write a dissent, especially also if you're also standing by yourself. And it's more so when it goes against popular opinion. You can't write a dissent or majority or any judgment in having in mind how this is going to be affected or received by the public. Once I wrote a dissent, and it was national news, and my daughter came home and she didn't know that I had written a dissent. She's an adult. She's, oh, Mom, who's that judge that said this? It just does not make sense. I said, that judge is your mother.
I'm talking to her.
Okay, do we have time for one short?
Yeah, please.
Okay.
I'm interested in the role of judges in the larger system. For example, should judges be elected at any level in any system? As we know, the many lower court American judges are elected. Should there be term limits where there are no limits? Should there be minimum and maximum ages of service? And I don't know how the South Africa system works. I wonder if you could help us with that too.
Want to walk us
I
through
think I
that?
could just take two quick questions, then you can answer it all at the same
a good
time.
idea.
You want to have
That's a good idea.
Both of you have.
Well, my question was related in terms of protecting the independence of the courts. How does the judicial selection process affect that, given that politics seems to be at play, whether there's elected judges or with the state's highest court, a commission to appoint judges?
Okay.
To the extent it hasn't been answered, if you feel it was in the other responses, but I wanted to know what role, if any, do you see or sense with implicit bias in terms of the matters that you deal with, in terms of the colleagues that you share discussions with, as to outcomes of cases, in the cases that are brought before you? Thank you.
I didn't get the last question.
The question was whether you see implicit bias in the court you sit on with your colleagues in getting to an outcome. Okay, so first question is about, we'll dig into South Africa here. Term limits, how are judges either appointed or elected at different levels, and are there term limits? Those first two questions we have.
No election of judges. Judges are appointed. We go through, they're appointed, but this, I'm talking about a system now since 1994. Before 1994, the Minister of Justice would phone somebody up and say, okay, I want you to be a judge from tomorrow. And then it would be published in the newspaper. New judge has been appointed by the president. Since 1994, judges, people wanting to be judges, got to go through public interview system. The Judicial Services Commission comprises between 23 and 25 individuals. 5 people are appointed by the state president. Majority political party in parliament appoints a certain number of people. Opposition parties appoint a certain number of people. Judges are represented, but judges are not as many as politicians on the panel. Academia, university professors are also represented. Civil society is represented. And so nominations are made. The nomination lists are made public, and organizations, people before the interviews can make representations to the Judicial Services Commission. Interviews are carried live on TV, on YouTube. You can watch all the interviews. Interviews are normally over a week or 2 weeks, twice a year. And in order to be appointed, the candidate has to get a majority of votes on the Judicial Services Commission. So if there's 24 members, they got to get 12 plus 1 votes. There has been allegations that there's bargaining between the members and different parties. If you vote for this candidate, we'll vote for that candidate. But there's no perfect system, but it seems to work.
And who sits on that Judicial Services Commission? So you have the appointers are from a different range of political parties or political actors.
Yes.
But the Judicial Services Commission is
and from Parliament as well, from the majority party in Parliament, from the opposition party, the judge president, or the chief judge from the province where the judge will be appointed is also represented. The attorneys and the advocates profession are also represented.
Okay.
For any position up to the Constitutional Court, the Judicial Services Commission makes the appointment. It's ratified by the president, but the commission who interviews the judges makes the appointment. For the Constitutional Court, if there's one vacancy on the court, the commission must interview at least 4 people and must give 4 names to the president, and the president appoints one of those names. And the president makes the appointment after consulting leaders of the opposition party within government.
are there term limits?
There are term limits, but the term limits are only for the highest court, only for the Constitutional Court. So at the Constitutional Court, judges serve either 12 or 15 years, and after that, they have to retire. At the lower courts, the High Court, Supreme Court of Appeal, they serve up to 65 years. From 65 years, they can retire, depending on how many years of service they have, and that goes towards their pension. So if you've served a minimum of 20 years in service, you can retire at 65. If you have not served 20 years, you can go until 70. If you serve 20 years, you have to retire at 70. If you have not served 20 years by the time you serve 70, you can continue, but the maximum age of a judge is 75. You cannot continue beyond 75.
Interesting. All right. So on the question of implicit bias, let's ask both of our jurists. What steps does the court take to guard against implicit bias coming into how judges make their decisions and the ultimate outcomes? I think that's a good way of framing it.
Yeah. Well, we have judicial training on implicit bias. Certainly, the chief judge, including the prior chief judge, have certainly focused on that issue. Many decades ago, we had the Franklin Williams Commission appointed that dealt with bias and other issues in our court system. And so this is an issue, not just implicit bias, express bias and racism. So this is an issue that New York has focused on for some time. But the devil is in that detail, right? I mean, the whole point is it's implicit. It's sometimes hard to persuade someone that perhaps something is driving them other than the merits of their decisions. And it may be hard to persuade a lawyer that perhaps the way they are reacting or acting is not merely driven by merit. So we do have training. We do have, you mentioned it before, ethical rules where judges can come up before the Judicial Commission in case there are charges that they have been biased in their decision making, in their conduct in the courtroom, if they violated other ethical rules that are not about implicit bias, but they may be about harassment, gender bias, and so forth. So we do have mechanisms in place. Let me say all of that is a work in progress. The job is not done. There is more to do. Part of the issue, I think, is a question of parity when it comes to numbers. Numbers do not resolve everything, but they certainly do address something. And you've got to have parity. We're doing very, very well in New York, but we're not certainly there in the numbers. But that does go a long way to change the tenor in the courtroom. It's very hard. Let me take it easy, an example. It's very hard to consistently be a misogynist when you're facing judges who are female. I mean, it's just very hard to keep doing that. You're going to pay a price in the sense of that the judge is going to point that out to you. You may be brought up to the Judicial Commission on that. And so numbers make a difference in the courtroom. Education makes a difference in the courtroom. And we are not immune to society's ever-changing, changes in society. As society moves in a direction, we all move in a direction. Judges are people too, kind of thing.
Do you have similar protections and training?
Yes, we do. Yes, we do. And coming also from entrenched racism, we had to have racist training. We had to teach ourselves, and it's for both ways, for white people and for Black people. And it's not just white people who can be racist; it's Black people who also can be racist. And it's that institutionalized racism, the institutionalized system that you come from. And imagine a South Africa where before 1994, where a certain race believed and they were taught that they were superior to other races. And that's why we don't have the jury system in South Africa, because of how do you unlearn in ordinary people some of those inherent biases. So we did away with the jury system because coming from our diverse past, it just did not work. So we have trained lawyers who sit as assessors in criminal trials at the choice of the judge. Bias is very important in South Africa because if you have a biased judicial officer, it's infringing one of your basic rights, your right to a fair trial. It's also infringing your right to equality. That's one of the enshrined rights in our Bill of Rights. So bias is viewed very, very seriously, but also very hard to prove. But we have standards, and that's one of the areas as well where we, in our case law, we try to teach and set out principles on how to determine bias. And how do we reflect on our society? We all have to recognize that we come with our inherent biases to the bench. And that is why in our Constitution, the Judicial Services Commission, which appoints judges, they directed that when they're making appointments, they must make sure that the appointments reflect the diversity that is South Africa. So what this means is if you've got 8 white male candidates and 1 candidate that might be a woman or black and for a particular area, the commission must look and see where we are appointing these judges. What do they need to make that bench more diverse, to make that bench more representative? So where all those candidates are equal and perhaps score all the same, then it is that criteria which may tip the scales as to whether the white male or the white female or the black female will be appointed, because they got to look at what do we need to strengthen the diversity of the bench.
In general, can you say how well South Africa is doing and with progress towards that goal?
Our judiciary is largely black. It's largely it's representative of the society and the community that we live in. Women representation is about 40%. Our parliament is one of the most representative in terms of gender in the world. Parliament.
Thank you.
Well, thank you all. Thank you, Judge Rivera, Dean Crowell, and Justice Theron. This was a really insightful and special conversation. My name is Allison Mori. I am the Executive Director of the Historical Society of the New York Courts, and I have the privilege to close out this program tonight. We at the Historical Society are very proud to partner again with Professor Andrews at New York Law School for this program that addresses the roles of New York and South Africa's judiciaries and how they ensure that there are independent and accountable court systems that fairly administer justice. Like New York Law School, as the Dean mentioned at the beginning of this program, the Society is committed to building responsible citizens that understand and respect the role of the courts in our democracy. Our mission is to preserve, protect, and promote the legal history of the state, and we are the only organization with that mission. To fulfill this mission, we produce a variety of programs, including events such as this one. We have student educational initiatives, publications, oral histories, and much more, and we very much appreciate your support. We invite our in-person attendees to join us at a reception that follows this conclusion, and we thank our virtual attendees for their attendance. And please, one final thank you to our participants, Judge Rivera, Dean Crowell, and Dr. Theron. Thank you all.